Welcome to The Probate Professor.
Hey everyone, welcome back to an all-new episode of The Probate Professor with attorney Taylor Waite over at the Clear Counsel Law Group. I am your host, Mike Leon. You know, navigating the Nevada probate system can be a little overwhelming, but you don't have to do it alone. Taylor has been helping Southern Nevada families clear the legal hurdles and protect their legacies with confidence and with clarity. And in today's episode, we're going to be talking about the long probate process and what happens in Clark County and why timelines vary. Taylor's going to break it down in just a second. So, Taylor, it's good to see you as always. I just came back from Nevada just recently, but let me ask you, I wasn't asking probate matters, but I do want to ask you about this with respect to Clark County, like I mentioned in the intro. A standard estate that's in Clark County in the year that we're in right now, 2026, what is some of the best case scenarios for folks listening on a timeline for the probate process? What should a family realistically prepare for?
Hello again, Mike. Really, it's great to be with you again. So I'll be honest, this might be my least favorite question because it's one of those where I think we have the least control over. I'd prefer to talk about my fees as opposed to talk about the timing because it really depends on so many factors, the courts, the parties themselves, even depending on the nature of the probate. Are we dealing with other professionals, whether that's CPAs or realtors or title companies? So I will give you an answer, even though I don't really want to, but it's a common question and it's one that we need to try to address with the clients to set some expectation of how long it's going to take. So we may have mentioned before, probate in Nevada is driven by nature and value. So that is also going to go to how long it takes. So in Nevada, if your estate is valued under $150,000 or you have a valid will that gives everything to a trust. And in response to this question, we're not going to go into great detail about the nuance of 150,000 and what that means and doesn't mean. But the reality is under 150,000, we can usually manage the probate within 3 or 4 months. That's a pretty reasonable time frame, assuming we have the information that we need and understanding that there could be complications, but that's a pretty reasonable time frame. If the value of the estate is greater than 150,000, then reasonable time frame, if everybody is diligent, it's like a best case scenario time frame. Again, all the information we have, parties are on board and everybody's being diligent. 8 to 10 months is a good timeline, but really we're looking at 10 to 12 as a reasonable timeline. And even statutorily, the courts aren't even going to look at a case as being, as taking too long until you're closer to 18 months. So 10 to 12 months is a very reasonable time frame. Even 18 months, given the various issues you may run into, is a very reasonable time frame for a normal probate, knowing that there could be lots of smaller issues that are going to cause delays in the process. But we'll work through it as quickly as we can.
Yeah. It's a good way to land the plane in terms of we'll get to it as quickly as we can. But let me ask you on that front. Is it because of, like, how is the probate court schedules looking in Nevada? Like, is there a lot of delays, is there a lot of high case volume? Like, what's happening with respect to the court schedules?
So in Clark County right now, I think our timeframes are very reasonable. I think when the courts are setting hearings, from the time we file a petition until the court sets a hearing, 6 to 8 weeks is what I tell people right now on the phone. And there's a lot that goes into that timeline when we say 6 to 8 weeks to a first hearing, which can change. Because when we file a petition, just a tiny bit of background, I guess, we file a petition, we don't set the date. The clerk's going to set the date, and usually the court clerk will give us a hearing date, meaning they'll return that back to us within a day or two. And that's usually 4 to 6 weeks from the time the court clerk responds. But if the court clerk takes 1 to 2 weeks to respond to the initial petition, which has happened recently, then it's still 4 to 6 weeks after they address it. So 6 to 8 weeks to a first hearing, or almost any hearing from the time that you file, that's a pretty reasonable time frame. When you talk about probate sales, like the selling of a home in probate, which often requires court approval or a court hearing, they try to get to those sooner, as you have a lot of interested parties that want to get that set for a hearing. So those can be set sooner. It's a slightly different calendar. But 6 to 8 weeks right now is a pretty reasonable time frame. And throughout Nevada, it's pretty close to that as well, depending on the courts. In Clark County, we have a couple of commissioners that hear cases first and it judges, but 6 to 8 weeks is a pretty reasonable timeline.
I'm going to make an assumption here. You tell me if it's true or not, that there is a mandatory waiting period for creditors to make claims, but is the reason because of how slow probate is? We don't want to rush regardless of how much everyone kind of agrees. Is that part of the reason why, or am I way off?
No, that is part of the reason. And it's interesting. It goes again to, I say the same thing over and over, but it really goes again to this idea of Nevada law, or Nevada probate, being driven by nature and value. So on the smaller estate end, you do have to wait a certain amount of time before you can even file, right? We may have addressed on the podcast before affidavits. To complete an affidavit to transfer title, which you have to consider creditors. You can't sign that for at least 40 days after the death. A set aside, which again, for estates less than 150, you can't file that for at least 30 days. And at least one of the rationales for waiting is to give the parties an opportunity to identify what creditors might be out there, because those need to be addressed. When you get into the larger or formal administrations, so those greater than 150,000, it's not necessarily a limitation on when you can initiate. It's a distinction of running a creditor period. So for estates valued between 150 and 500,000, Nevada law requires that you run a 60-day creditor period during the administration. If it's greater than 500,000, then you have to run a 90-day creditor period. Being diligent about identifying creditors and making sure that they get notice during that period so they can file claims and then you can address them. But that also does not hinder the other administration of the estate. You can still, during those 60 days or those 90 days, you can still sell assets, sell a car, a home, manage a business, continue litigation. You can still do those things during that creditor period, but there are limits in what you can distribute or what you can pay out until you get a full picture of a full creditor picture as far as what's due or what's not due, and the values and things like that. So you have to address it on the statutory timelines, and an administrator should be careful, certainly not to pay creditors during the creditor period, but also not to pay beneficiaries until you get a full picture after those creditor periods run.
Taylor, we've talked about wills before on the pod. Does having a valid will speed up the timeline once you actually do get to that hearing date, or is it the court process is the same length even if the instructions are super clear within the will?
To make those listening feel better about the fact that they have or a parent has a will, it can make it more efficient. It gives more details, helps identify parties. But the reality is it doesn't speed up the process. The timing for petitions, the running of the creditor period, all that's going to run the normal statutory periods. Recently we've had, I can think of at least two situations. One situation sitting down with an only child who had a will from his mother, and he was quite upset that, one, he had to pay attorneys anything, and two, that it was going to take more than a couple of weeks. Ended up taking 3 or 4 months. The value was under 150. But he was quite upset that it required any court intervention because he was certain that the existence of the will should have allowed him to avoid that. But it does not. So yes, it can be more efficient, certainly allows for more information to be available to us, but the process itself is the same. The timing is the same. So it's good to have it. It's absolutely good to have it. It's the best way to identify what you want. I mean, there are other ways, It's a way, and one of a good way to identify trusts as well. But yeah, it makes it smoother, but isn't going to shorten it.
Well, that's good to know. But let me ask you about, you mentioned under 150,000. I mean, obviously one of the large assets people have is a home, right? And that needs to be sold. Does that usually kind of put the probate process on freeze, or is the legal side still playing out while the house is on the market?
That's a great question. And another common question. It shouldn't freeze the process. It can slow it down because it's going to typically requires hiring other professionals and other parties getting involved. We talked in another session about some of the responsibilities. So a home and the selling of a home, it can include repairs to a home or cleaning up the home. Sometimes, honestly, it's just cleaning out. Mom and dad lived in the house for 50 years. So it's just a matter of cleaning out 50 years of stuff, some which has value and some does not. But you are correct that all of that can be done during the process. If we go back to the creditor period, you can do all that while the creditor period is running. But it can delay the process. Sometimes the family will choose, if you look at the market, I'm no real estate professional, but my general understanding is you'll see the market dip a little toward the end of the year and then go up again. You get into the springtime, people again looking for property. So sometimes you'll have families that will ride that out. Even though you could push forward with the sale, you can keep the probate open and then list it when the market's a little better. There's risk there as well, but it's more a delay in the issues that owning a home in probate or having a probate will arise, whether that's dealing with the mortgage company, dealing with liens. In Nevada, as you can imagine, solar liens give us some issues, and those solar companies. So it can be a process. And then when it comes to selling a home, and we're not going to get into great detail on that, but there are some options when selling a home that are helpful. There's a traditional process. You set it for hearing, and there are benefits to that. But we try, as a matter of course, in all our petitions to ask the court to grant what's called independent administration, which comes with a lot of nuance itself, subject to some dispute in Nevada as far as its usefulness. I see it as a great benefit because it gives other options to an administrator when it comes to selling a home or assets that can streamline the process. When you have disputed cases, it can be a little problematic, but you can address those. It's at least an option that's available. So the short answer, yes, a home in probate, it won't freeze it, but it can certainly extend the timeline, but can be done. Managing it, cleaning it up, selling it can all be done during the general process of the administration.
Taylor, you just mentioned contested, so I need you to expand on that. So my understanding, because probate is a public process, if one family member does decide to challenge the will, how much does that that contestment kind of add to the life of a case? Does it add to the life of a case?
It will add to the life of the case. And in true legal fashion, the answer is, of course, it depends. When it comes to challenging a will in the state of Nevada, the challenge typically comes in three broad categories. So a will is going to be challenged on fraud. So someone made up the will. That might be one of the challenges. It could be challenged under an idea of duress. It's, to put it crudely, it's the proverbial gun to the head. They only signed it because they were forced to do it. Or it's a subject of, or a product of incapacity. They didn't really understand what they were doing. But if you consider those three, whether that's fraud, duress, or incapacity, those are very fact-intense questions. So if you get into a challenge of a will, it's likely that you're going to get into depositions of neighbors. Who were they talking to at the bank? What was being said when they were talking to their doctors? You're pulling medical records, who had access to them, who was controlling medications. You can see how it really could extend the timeline of any probate as you get into all of those details. So could it be resolved in a few months with a couple of motions if it's sort of a single issue that could be addressed? Yeah, it could. But we have also seen some of these it'll extend a probate out years as they work through all of these issues to depose doctors and pull medical records and all the depositions of, again, neighbors and friends and family to work through that. It can really extend the process while you're trying to figure out what was intended.
Taylor, as we kind of wrap here, I would love for that family that's listening to this right now, and they're like, you know what, I'm going to use the Clear Counsel team. I like what Taylor's throwing out here. Let's talk about some of the ways your team works to kind of, make sure there's no paperwork traps with respect to the case, so it doesn't get kicked back, by the probate commissioner and cause bigger delays. What are some ways that your team works with somebody that's coming on board as a client?
So, Mike, thanks for that question. Recently, we met as a team, as a probate team, and I was trying to think, and we were trying to think of a theme that would help us as we deal with clients, as we deal within the office, trying to be as efficient as we can. And what we came up with is this idea of distributions in the details. And you hate to boil it down to just the distribution, but the reality is, if you think of that phrase, distributions in the details, that gets us to the end. So if we have that in mind from the very beginning, then what we need from clients and where we run into issues, those sort of paperwork traps, as you indicated, as much information as we can get up front. And this goes to, as detailed as the way we spell someone's name, the address where we're giving them notice, legal descriptions on properties that are going to be transferred or sold, the nature of the will, so who had access to the will. So we are really driving it on our end and trying to do a couple of things. One, educate the clients as best we can without too much detail about the process itself. Because if they understand what we're going to have to give to the court, then they will better understand what information they need to give to us. And then us better understanding the process and the details we need, that will help us better ask questions of the clients, really try and get as much information up front. The sooner we can get it, the better. So again, crude may not be the right word, but if we think about that, distributions in the details, because that is the end of a probate, hopefully, is that we're distributing the money, distributing the assets, whatever that is, and closing it up. And to get there, we need detail, as much detail as they can give us, right down to the way they spell their middle name, because that can cause a delay in the end if you're dealing with a bank or some other institution. So we do our best to ask as many questions as we can, and hopefully they will give us as detailed and correct information as we can get.
I love it. Distributions in the details. Put it on the masthead, Taylor. Thank you for the time and the insights. I appreciate it.
You bet.
And thank you to everyone out there for listening to this installment of the Probate Professor. If you're navigating a probate matter right now in the state of Nevada, don't let that legal process overwhelm you. Visit Taylor and his team over at clearcounsel.com to get that clarity you need. Schedule that consultation today. And do me one more favor before you go. Hit like, hit subscribe, leave a review, comment, share the episode with someone who needs to hear it. I'm Mike Leon. We'll see everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.